Hi, everyone. Welcome to the Global Remote Working Tax and Employment Considerations webinar. I'm very happy to see that we've got a big group of participants. This is obviously a topic which has really become very topical in recent days. My name is Aneria Bouwer. I'm a senior consultant in the tax team at Bowmans in South Africa. And just going to run through a few housekeeping matters. As participants, you are all automatically muted and the chat functionality has been disabled. Should you have any questions during the webinar, please make use of the Q&A function. Your questions will be submitted to me, and to the extent that it is possible, I'll select a few of them to discuss with the panel. Please note that there won't be any written responses to the questions. And finally, the webinar is being recorded and a copy will be available on our website later today. Right, so as you all know, today we're sitting in a very different world than 2 years ago. And one of the big changes brought about by the lockdown rules in the various jurisdictions is that lots of people had to work remotely. They didn't have any choice. And we had some interesting questions during the lockdown where employers would have only found out after a couple of months that they had an employee working in a foreign jurisdiction. And during this time, employees have become used to working in foreign jurisdictions, and many would now like to extend that. So even with employees returning to the office in many jurisdictions, there is now a drive for employees to work remotely in a foreign jurisdiction. In this morning's webinar, we're only going to look at remote working in foreign jurisdictions, so not work from home in, for example, the South African context. The difference with what we see now with remote working is that it is employee driven. It's not employer driven. In the past, we would have had an employer wishing to establish a presence in a foreign jurisdiction and sending employees there. Now we've got the employee who, for some other reason, personal reasons, lifestyle, etc., want to work in a foreign jurisdiction and asking the employer to allow them to work in that jurisdiction. And often they will pitch it to say that it doesn't really make a difference to you. I'll sit in, for example, the UK. I can continue working for you as the South African employer, and it won't really make a difference. So it's a win-win to allow that. However, there are, as lawyers, we obviously have to point out the risks in that regard. And this morning, we're going to unpack some of that for you in the session. And if we look at the scenario where we've got a South African employee working in the UK, but still for a South African employer, there are lots of questions that come up, such as which country has the right to tax the salary paid to the employee? What is the impact on the employee's remuneration package, pension fund, medical aid, leave entitlement, etc.? Could this expose the employer to the jurisdiction of the labour courts in the UK? Is there an employee's tax withholding obligation? And often something which is overlooked, which is extremely important, is could it expose the employer to an income tax, a corporate tax liability in the foreign jurisdiction? So as you can see, that's quite a mouthful. And I think the trickiest part of this morning's webinar will be to keep to our 1 hour time slot. We received a lot of questions before the webinar, and we've incorporated some of them into the questions, which I'll be asking the panelists. But some of them are actually webinar topics on their own, and we cannot deal with them in the space, in the time that we've got this morning, such as there were questions about the use of professional employer organizations, about appointing employees as contractors. We were asked to give an overview of the implications in the various African jurisdictions. Unfortunately, we won't be able to deal with all of that, but we'll deal with a number of tax and employment law questions in the context of South Africa and the UK. Helping me unpack it this morning will be our panelists. We are very fortunate that we've got Simon Gough and Elizabeth Lang from Bird and Bird assisting us to provide the UK input. Simon is a legal director at Bird and Bird's London-based tax group, doing a lot of multi-jurisdictional work, coordinating cross-border tax advice, and working with tax colleagues around the globe. Elizabeth Lang is also a partner at Bird and Bird in London. She specializes in employment law. She's based in the London office, but she works as part of the international HR services team. Then we've got Wally Horak, the head of the tax team in Cape Town. I think most of the South African tax participants on this call will be familiar with Wally. He's got years of experience, and he was one of the first South African tax practitioners specializing in international tax with a wealth of experience. And then we've got Helen Wilsenach, a partner in our Johannesburg office, employment and benefits practice. She specializes in employment law and advises on a range of issues. I'm Aneria Bouwer. I'm a senior consultant in the tax team in Cape Town, and I'll be the one herding the cats this morning. Please keep in mind, the scenario we're looking at is employee-driven, not employer-driven. We're not dealing with immigration laws. Those are also a webinar on its own. And we're just looking, by way of example, to the South Africa and the UK this morning. So if we can start with some questions in the context of an employee of a South African company who has indicated that, let's just say he, to make it easier, he has moved to the UK and wish to continue working for South African company in the UK. Helen, one of the questions which employers often would like to know is which laws will regulate the employment relationship? Will it be SA or the UK?
Being a lawyer, I'm not going to give you a simple answer, but the short answer is that it depends. And what we often see with clients is that they get over the immigration law hurdle, and then they kind of just assume it's going to be a seamless online transfer. So in many jurisdictions, and Liz will speak more specifically to the UK, but by moving over there, you can trigger their statutory employment laws in terms of having to provide basic employment laws, kind of the basic employment leave entitlements in that jurisdiction. It can trigger fair termination provisions. It can trigger certain registration obligations like social security, occupational health and safety obligations, even if the individual is working remotely from their own house. So the first thing that you would always want to check is whatever location you're moving to, let's say it's in the UK, with a local lawyer as to what it will trigger and that you're comfortable that you can comply with those obligations. It also doesn't mean that you have cut all ties in terms of South African law. You will have lessened your risk of an unfair dismissal claim in South Africa because locality of the undertaking is often the trigger for our employment tribunals assuming jurisdiction over an unfair dismissal claim. But equally, that's not the test if there's a claim over benefits or of incentive scheme rights. There they will look at which is the place of closest connection. So Aneria, the short answer is if you are relocating to a different jurisdiction, you really need to take local advice because it may well trigger local laws. And it also doesn't necessarily mean that there are no legal obligations from an employment law point of view still in play in South Africa.
Thanks, Helen. So Liz, from a UK perspective, so you're contacted by a South African employer who wants to know they have either consented to or just found out that there is an employee working in the UK. What is the risk of them being, for example, relying on the UK labour courts?
So, yeah, I mean, there is a real risk that someone who happens to be working in the UK, even under a very South African contract and doing all the work in South Africa as if they're in South Africa, but happening to be based in the UK, there is a risk that they could accrue mandatory rights in the UK. We have quite a host of rights in relation to dismissal, which kicks in when someone's had 2 years of service, which would include previous service in South Africa, discrimination, whistleblowing, victimisation, and rights to minimum levels of paid holiday and pay, etc. I think the key, it's a question of fact and degree, really. So you could have a situation where someone happens to have got trapped, for example, during the pandemic in the UK and is here, but didn't really intend to be. You have people who are, as you described in the introduction, making a lifestyle change and want to carry on working for the South African employer, but in the UK, but as if in South Africa. Now that becomes a little bit more complicated, and the period of time, etc., may actually bear on the UK courts' willingness to give them rights in the UK. The point is, I think, overall, to stress that even if you're applying South African rights to the employee, you can't stop the UK courts from giving protection to the employee as well, or instead of, if the tests are met in the UK. Broadly speaking, the test is whether someone is ordinarily working in the UK. Now, if someone has a place of residence in the UK, that's likely to be quite persuasive. There was a case where a US businessman who happened to be in the UK for 49% of his time tried, but failed, but he didn't have any place of residence. He just happened to work here a lot. So you can see that it may vary quite a lot. What I would say is that in practice, probably the issue is likely to be when there's a point of contention between the employer and the employee, or a dismissal in particular. And at that point, it is worth bearing in mind that it is free to bring a claim in the tribunal in the UK, and it's supposedly quite an employee-friendly forum where you don't necessarily need a lawyer. So it can be quite tempting for employees to try to bring claims, even if ultimately they don't succeed. It's also just worth bearing in mind the laws are slightly different in Northern Ireland and Scotland to the laws in England and Wales.
As lawyers, we never make things easy. Helen, something I think quite mundane, such as leave days. So if your employee is sitting by own choice in the UK, can you force them to work on UK public holidays? Or maybe that is, that's between you and Liz then, but you obviously want them to be aligned with the rest of the South African workforce.
So before I hand over to Liz, and this you always need to be careful about double dipping. So you've got to be careful about just relying on your existing employment contracts and thinking that will be fit for purpose, because exactly that, the individual is likely to want to take UK bank holidays and enjoy it with their family, but you as a South African employer would want them to be working on those days and aligned with your work hours. So from a South African point of view, you could require them to work, especially if we're dealing with individuals who earn above a certain threshold, and we're assuming that South African Basic Conditions of Employment Act doesn't reach. But the short answer is that you would want to regulate this in an addendum, at least to the employment contract, where you make the point clear that you're agreeing to them to relocate, but these are the terms and conditions, one of which is that they're expected to be online for English public holidays, and they can take their South African public holidays off unless the employer agrees otherwise in writing. So you want to avoid double dipping, and you want to be very clear going into the arrangement that you've regulated it clearly.
From a UK point of view, I would completely agree. If you're trying to retain South African employment rights as being the ones that apply, and the story that the employee just happens to be working from the UK, but is, to all intents and purposes, subject to South African rights and obligations. There's certainly no right for an employee in the UK to take public holidays, English public holidays, office holiday. There's right to paid holiday, minimum number of days, but not on designated days. So I would absolutely advise the employer to insist on having the employee working as if they were in South Africa.
Right, thank you, Liz. Now, from a tax perspective, what we often see is that because this is employee driven, it will start with the employee talking to HR, moving to the UK, and then at some stage they'll think of speaking to the payroll of the South African company. Either complaining because employees' tax is still being withheld, or otherwise just asking why they are still being taxed, and that's quite a complex question. From a South African employer's perspective, you have a withholding obligation, and often, and that's what we see often with questions that we receive from clients, is that they don't know what the position of the individual is. They don't know, is the individual still tax resident in South Africa? Has the individual become tax resident in the UK? And that is one of the main questions to understand when it comes to withholding, is what is the tax position of the individual? From a South African perspective, if the individual is still tax resident, then the employer would still need to withhold, except to the extent that the individual qualifies for the so-called foreign earnings exemption. And we're not going into the detail of what that means and how you qualify for that, except to say that there is a cap of 1.25 million rand. So that exemption isn't really the full answer. If the employee is no longer tax resident in South Africa, then there will be a different question as to whether or not the employee still derives income from a South African source, as that could expose the employee to South African withholding tax. Wally, is there anything that you would like to add from the SA employer's perspective?
Yes, I mean, normally the question immediately arises whether the employer could become subject to tax in the other jurisdiction. And that depends a bit on the other jurisdiction, to what extent that they regard the activities of the individual as participating sufficiently in the economy of the other country. I think Simon will give us a nice example of a court case which deals with the issue. But the biggest question is whether the South African employer will have a permanent establishment in the UK by virtue of the presence of the individual there. Maybe Simon can expand on that part.
Wally, sorry, can we leave the PE question for a little bit later and first just deal with, I think, the employees' tax withholding? Simon, if we could move over to you, when would the UK have the right to tax someone working in the UK? And I know that all of us, we've come across the concept of res, non-dom, etc. And I know that can become very tricky. But the basic question is, if there is someone working in the UK, when would the UK become entitled to tax them?
As you say, can be a fairly complex question, and the extent to which an individual is subject to UK tax really depends on whether they're resident here, and we now have a statutory residence test, or, as you say, whether they're domiciled in the UK in a relevant tax year. So far as the statutory residence test is concerned, I could speak for a whole hour on it, so you'll be relieved to hear that I'm not going to. But you need to apply a number of tests in a particular order. There's a so-called automatic overseas test, an automatic UK test, and there are so-called sufficient ties tests as well. But sort of to cut to the sort of real basics, if an individual spends at least 183 days in the UK in a tax year, they'll meet the first automatic UK test. So in practice, that's the very first test to consider, as meeting it means that it's impossible to meet the automatic overseas test. So you're going to be resident here, sort of basically if you're here for more than 6 months. Less, you can still be deemed to be resident going through some of the other tests, but as I say, sort of it's a complex area. You'd have to take advice in relation to each case. So where you've got an individual who's both resident and domiciled in the UK, they've got the strongest links here, and they're going to be subject to UK tax on their worldwide income and gains on an arising basis. Contrast that to an individual who isn't resident here nor domiciled in the UK. They've got the weakest links, but they're still going to be potentially subject to UK tax in relation to income tax on their UK source income. And obviously if they're working in the UK, they may well have a UK source. Obviously, we've got to sort of overlay that the UK-South African double tax treaty, and that does itself have an employment sort of article, which again sort of has a number of components to it, and it very much depends on residence, the presence of a permanent establishment, which we'll come on to, as to whether, you know, where you've got someone who remains South African resident but working in the UK, whether they can get out of UK tax or not. So very much fact specific and sort of very dependent on the particular circumstances.
Thank you, Simon. Just to get back off to the concept of residence again, it is important for the South African employer to ask the employee about his or her tax residence. And there are various considerations to keep in mind in respect thereof. So for example, if you've got a South African who ceased to be tax resident in South Africa, there's a so-called an exit tax. And that is very common in many jurisdictions, that if you cease to be tax resident, then you will have a liability to pay capital gains tax on certain of your assets. And again, that isn't something that we can go into in detail on this webinar, but it is important for employers to advise their employees to obtain advice with respect to their personal possession. And it's also important to know whether this is short-term or whether it is a longer-term arrangement. If it is short-term, Simon, if I understand correctly, then let's say it is just for only 4 months and the individual works for a South African employer, then the UK shouldn't have the right to tax that employment income.
That's right, subject to the UK source rules, which I was talking about, and the overlay of the double tax treaty. So long as they're not constituting a permanent establishment in the UK, then the article would get you out of UK tax. Okay. But again, beware that there is a treaty override there, and you may have to sort of make an application in order to apply it. So again, there's an administrative process to be gone through.
Thank you. So from a South African perspective, while the individual remains employed by a South African company, the person will still be paid via the South African payroll. And as I mentioned earlier, and I think I may have hopped over it a bit too quickly, the question as to whether or not the employer has to withhold starts with the question of the individual's tax residence. Obviously, what one wants to avoid, Helen was talking about double dipping. I suppose this is a double whammy. You don't want tax being withheld both in South Africa and in the foreign jurisdiction. So this is something that one would need to give attention to. I think one of the concerns of an employer in remote working is the obligation to register in a foreign jurisdiction. And again, without going into the details, Simon, if my understanding is correct, there is in certain circumstances, or there may be a risk that the employer, South African employer, would have to register in the UK in order to withhold employees' tax in the UK?
Yes, that's right. From a UK sort of pay-as-you-earn, PAYE and national insurance perspective, it's very much a question as to whether the employer has an appropriate presence in the UK. Now, obviously, if they're, if they've got a permanent establishment here, and that begs the question as to whether the employer themselves constitutes that, the employee themselves constitutes that permanent establishment, which we'll come on to discuss, or whether or not the South African company also has for example, UK subsidiary, which might be a sufficient tie, or indeed whether they have sort of a so-called representative office with assets here. That might be enough to require them to have to register an account for PAYE national insurance in the UK in relation to employees who are resident here. Again, it's one of those questions which very much turns on its particular facts. If there's no presence, then the employee themselves will have to account. But often, even if the employer doesn't have the sufficient presence, they'll want to help their employee, and they'll often sort of appoint a separate independent payroll agent to take on that role for them in the UK.
Thanks, Simon. I think we've dealt so much of, we've mentioned permanent establishments often. Maybe it's just time to move on to that, because I think that is something which is often overlooked. If the employee says, I would like to work in the UK, it's not the employer sending the employee there. But there is a risk that an employee in a foreign jurisdiction can provide or can create a taxable presence. Now, Wally, I'm not sure if you would like to just start with the PE concept. I know that the UK has had some specific case law, which is very useful, but if you can maybe just provide the South African perspective, and then we can move over to Simon.
Yeah, maybe I'd go a bit further and look at the OECD commentary on the double taxation agreements, because that's usually relevant in both countries. In terms of the OECD commentary, if a person represents a firm or enterprise of one contracting state in the other contracting state, merely as an employee, without even the ability to conclude contracts on behalf of that employer, it could suffice to be a permanent establishment. There's a fine line, where the question goes a bit further and say whether the premises occupied by the employee is at the disposal of the employer. In other words, there must be some ability of the employer to dictate how the use should be done, or who can use that premises. If it's a home office or the own premises of the individual, it's a bit more unlikely that it will constitute a permanent establishment. I think that's where the UK case was so useful. Simon?
Yes, thank you, Wally. As you say, it's very much a question of sort of, is the Home Office at the disposal of the employer? So very much, again, we're looking at sort of matters turning on particular facts. Clearly, if you have someone who sort of works from home but is actually someone out sort of as a representative of the South African employer, out and about on the road, and just happens to do a little bit of admin at home, that's probably not sufficient. But as you say, the OECD commentary has been evolving over the years, as has sort of case law in various jurisdictions. So if you look at the sort of the latest OECD commentary, and if you bear with me, I'll just read it to you. It says, whether or not a home office constitutes a location at the disposal of the enterprise will depend on the facts and circumstances in each case, as we discussed. In many cases, the carrying on of business activities at home of an individual e.g. an employee, will be so intermittent or incidental that the home will not be considered to be a location at the disposal of the enterprise. Where, however, a home office is used on a regular and continuous basis for carrying on the business activities of an enterprise, and it is clear from the facts and circumstances that the enterprise has required the individual to use that location to carry on the enterprise's business, for example, by not providing an office to an employee in circumstances where the nature of the employment clearly requires an office, the home office may be considered to be at the disposal of the enterprise. So it's gloriously unclear, in other words. Therefore, sort of, what can you do to ensure, or to at least seek to protect yourself, that you don't suddenly end up with a permanent establishment by virtue of a remote worker deciding, I'd like to stay in the UK. We've talked already in terms of sort of employment law about sort of making sure that the contractual terms sort of outline the fact that you are an employee of a South African country, and therefore it's important, I think, also from a tax perspective, to ensure that the contract is sufficiently sort of tight to try to negate any argument that the Home Office is really just an adjunct of the employer's sort of office back home. So the contract should sort of require the employee to work from the home jurisdiction, i.e. the South African office, but permit them, subject to sort of appropriate checks and whistles, to work from home, if it suits both. What's important is that the employee doesn't have business cards with their home address on. They shouldn't have, a direct line in, etc. So sort of very much it should sort of be made to ensure that sort of working from home, as it were, is a convenience to both, but not a requirement, certainly not a requirement of the employer. And in fact, you should have them coming home from time to time to the office. But this is an evolving area. We have seen case law in various jurisdictions where sort of the tax authorities have pushed this, and we've seen some quite surprising outcomes. And I think we'll potentially see more of this. I think what has sort of made people perhaps lulled into a false sense of security is at the beginning of the pandemic, we had the OECD quite helpfully saying a permanent establishment is something that has to have a degree of permanence, clues in the name. Where someone is simply stranded in a jurisdiction, as happened during lockdown, that won't in itself sort of create a sufficient permanence in order to sort of meet the test. And therefore there was sort of almost a relaxation during the pandemic. And for example, the UK tax authority said, yes, we will follow that OECD guidance. Interestingly, not all sort of, for example, European jurisdictions did sort of say that explicitly. But that was during the pandemic. Now people aren't sort of locked in the UK we're supposed to be getting rid of all of our rules in a week or so. So people are free to go home. But I think people think, oh, it's been okay up to date. No one's been chasing me. Things will change, and we're back to the rules as they were, and with this guidance and this evolving set of case law. So I think it's very much sort of, important that employers do think about this very carefully and take appropriate advice.
Okay, so clear as mud going forward. Helen, just going back to you and Elizabeth, and then we'll go over to you. One of the questions is also more practical, relating to, for example, benefits. So you've got an employee who's a member of the South African Retirement Fund, a member of the South African Medical Aid, And I know a lot of it will depend on the specific rules and the specific schemes. But in principle, if they're moving to the UK, and let's say it's not on a short-term basis, it's not only 3 or 4 months, should or could they continue contributing or participating in the South African Retirement Fund and Medical Aid Scheme?
And so bearing in mind in South Africa it's contractual, those rights are contractual, not statutory. You really have to read the rules of the fund, which no one ever does, because a lot of the retirement funds make no mention of residency, and often in employment contract, it's a condition that you belong to a particular fund. And I know from a tax point of view, though, it may not be attractive for an employee now based in the UK to want to continue contributing to the fund. So the point is that before people relocate, you need to understand what the fund rules are. Are they quite rigid? Do they cater for it? Do the fund rules require amendment? And does the employment contract require an amendment? Bearing in mind that other employees may have an issue if you say, well, we have to join and we don't want to, but you're allowing other people to opt out. Medical aid probably a bit less controversial because it won't make sense in most cases to continue contributing to South African medical aid when you're based in the UK. But then that triggers questions of, well, if the employee falls ill, can they access the NHS or a local, the local medical network there? In other jurisdictions, unlike the UK, there might not be a very good one. Do you look at your insurance policies and see if they cover individuals who fall sick? So the point is, just to sum up, is you need to look at your benefits regime when someone relocates. It may not be flexible enough to accommodate it, and it may have a knock-on impact on what you do from kind of fairness laws on what you allow other employees to do. So you've got to give it careful consideration.
Thanks, Helen. Listen, in the UK, would there be, is that also regulated by contract, or would there, for example, be an obligation on an individual to belong to a retirement fund in the UK?
In the UK, you can opt out of what is obligatory, and that is an auto-enrollment scheme that employers have to pay a percentage of salary into with matching contributions by the employee. But most people use pension schemes in the UK as a way of saving tax because it's tax efficient. So I think that sort of feeds into whether someone is taxed in the UK as to whether or not they may be interested in having a pension in the UK. But most other benefits are social security based, and again that feeds into whether they're paying national insurance in the UK and having that deducted. Sick pay is very low, but it is based on the tax. Okay, so in practice, I guess South African employer would probably you'd have to reach an agreement, and if South African pay did not apply as a matter of contract or law, just decide whether the employer is going to top it up as if they were in South Africa. Terry.
Thanks, Liz. Wally, and going over to share incentive schemes, which is again something which is regulated by contract, the participation thereof, etc. But could if an employee belongs to a South African South African incentive scheme, and they start working in the UK, what would the impact thereof be from a tax perspective?
Once again, it depends a bit whether they're subject to tax in the UK, but let's assume they are. The OECD guidelines are again very important. The indication is that one should split the tax on that benefit realized over the period of the incentive. For example, if it's a 5-year scheme where the shares vest after 5 years, you look how many years or days the individual worked in South Africa and how many days they worked in the UK, and then you apportion the tax between the two countries. That is rather complex because we have to explain this to the authorities, and you have to obviously decide which entity, if there is an entity in the UK or a payroll agent, will deduct the tax in the UK. From a South African point of view, the employer will remain liable to deduct the the tax on the portion allocated to South Africa. So Simon, maybe you can explain what happens in the UK.
We unsurprisingly do follow the OECD apportionment rules. So just as you say, Wally.
Okay, so the tricky part is if there is no employer registered there, but just a payroll agent, how do you do it through there? Do they simply get the information about the apportionment?
Yes, you'd have to ensure that the agent has the information to be able to sort of work it through the payroll.
Thank you both. Before we move on to the reverse scenario where you've got a foreign employer, so a UK employer with an employee moving to South Africa, which I think based on the cost of living makes more sense. It's a lot more beneficial to earn pounds while living in South Africa than vice versa. What comes across is that this is obviously not simple, it's not straightforward. And one of the questions that were asked before the webinar is this an employee right? Can the employee simply tell the employer that they are going to work in a foreign jurisdiction, or can the employer compel the individual to work in South Africa? If we're looking at a South African employer, I mean, I think what is quite different from a UK perspective is you're very close to the rest of, or to the European Union. So it's quite conceivable that someone will, let's say, work in London and live in Portugal, or vice versa. If we're looking at individuals moving not to neighboring countries such as Namibia or Botswana, etc., but we're looking at individuals working in a foreign jurisdiction, that tends to be on a more permanent basis, because you don't go to the UK and fly home over weekends. So that's obviously a very different scenario. And I think for South African employers, that makes it a more weighty question. So Helen, from a South African law perspective, would this be something that an employee can insist on?
The short answer is no. I mean, it's a change to term and condition of employment generally, and that requires agreement both ways. What we have seen is a bit of a knee-jerk reaction to bringing in place remote working. And that's fine, but I think you've got to be very careful about hardwiring rights if you're not sure as an employer that it's going to work for you. So our advice is you can have a policy on flexible working, which maybe allows someone from a lifestyle choice to relocate, but you've got to be careful of creating a right, because once that's become a term and condition, you can't say it's not working for me. Sorry, next weekend you need to come back. It may be that if you've left it in place for 5 years, it's become a term and condition, but the short answer is seen quite a lot of knee-jerk kind of granting these rights. You want to attract skills, you want to do that, but you should try and make it clear it's discretionary, it's subject to review. The risk is you may lose the individual because they may decide if you change your mind, but you don't want to create a right, because also if you give one employee a right, from a fairness point of view and a discrimination point of view, you may have to give others. So you need to be quite careful of how you do it, and think of the knock-on impact of what you do for one employee if others start demanding the same type of arrangement.
Thanks, Helen. Lesson in the UK, is the position fairly similar?
Yes, it is. I'd echo what Helen says. It's pretty much the same, actually.
Okay.
And could I just add, sort of overlaying back to the tax issue on permanent establishment, again, it's positively helpful from a tax perspective if the contract does require the individual to have its principal place of employment in the home jurisdiction, with a discretion, as it were, to allow them to work from home if convenient, and it doesn't interfere with the carrying out of their employment duties. Again, going back to that, is the Home Office at the disposal of the employer question?
Thanks, Simon. I must say, when we started advising clients on employees working in South Africa, it was quite frustrating, the number of potential obstacles or complications If you send an employee, or not send, if you allow an employee to work in South Africa, the risks from an employment law and a tax perspective. But this seems to be something that jurisdictions worldwide are grappling with, because it's very definitely a new way of work. It's not something which was common before the lockdown rules. And I suppose it will take some time for countries to adapt to that. We've got about 14 minutes left, and I've left less time for the reverse scenario for employees of a UK company coming to South Africa, because lots of there are very similar principles that apply, although obviously the details will be different. So Helen, if you've got an employee of a UK company working in South Africa, what would be your advice regarding the risk of becoming liable to comply with South African employment laws?
Just in brief there, I think to be a fairly high risk. Our laws haven't really evolved to take into account this flexible remote working, but it would trigger, they would almost definitely, if they were here on a more permanent basis, be able to align our basic conditions of employment act, which is less of a concern because a lot of them don't apply to higher earning employees, and would probably be quite similar to kind of leave days they get in the UK. But more concerning is that it may trigger registration obligations for things like unemployment insurance fund. You'd need to look at our workers' compensation, COID. It could also create a risk that you'd have to register as an external company. So the law doesn't require you to be a registered employer in South Africa. We have lots of people who are employed by overseas entities, but it could, the requirement in terms of our Companies Act could be that you have to register because you've entered into, as an external company, because you've entered into employment contract here. Just to sum up, you would have to make sure that you're familiar with South African law, which is very employee friendly in our registration requirements. And as a rule, if you are not paying the individual in South Africa, if you're not running a payroll, and then if you're not carrying out business as an employer in South Africa, so this is purely to accommodate. We've had quite a few employees, love interests are based in South Africa, or they want to live in Cape Town. All of your employment risks, registrations decrease. But as soon as you're paying the individual in South Africa and keeping a very high level, or you're carrying out some degree of business, then that increases your employment risks. And just one note is you've also got to be careful of data protection. You could trigger our new data protection laws if you become domiciled in South Africa and that employee starts processing personal data on your behalf. Let's say if they're in an HR function, you could trigger our data privacy laws in addition to your own. So the long and short of it is, I see our president has suggested a digital nomad's flexible working visa. So the government is very much aware of this and wants to attract this type of employee, but our employment laws are still fairly rigid and you'd need to take advice.
Thanks, Helen. So if you say paid in South Africa, do you mean if they open a South African bank account or if the employer has a South African payroll?
I mean, if the employer runs South African payroll, if the funds, then basically their salary and compensation is being paid directly into South Africa, just the way a lot of our registration laws, employment registrations are, I think the risk is heightened. And if they're not paid in South Africa and they're just living here, but they're not carrying out any work for the company has no business in South Africa. It's not a market to do business in.
Thanks, Helen. Leslie, from a UK perspective, would UK employment laws continue to apply even though they are working in South Africa?
And it's very fact specific, lots of case law on this, up to the Supreme Court and back. But essentially the test is whether there's a sufficiently close link between the employment relationship and Great Britain. And there are various categories, but what I would say is there was a pre-pandemic case where someone went to work in Australia to carry out their UK-based job as if they were a UK employee, but chose to work at home in Australia. And that employee did have the right to bring a claim in the UK, even though she was not working in the UK. So there was a close connection in that situation. And as I say, and whether someone will bring a claim from South Africa in the English tribunal is another practical matter, but they could certainly have a go and it doesn't cost anything.
Thanks, Liz. If we now look at the liability of the individual to pay income tax in South Africa, Wally, when would a non-resident individual become liable to pay income tax in South Africa?
Well, according to our source rules, it's, the source of his income or his salary is where he renders the services. So it will be South African sourced income as soon as he starts working here. The question is whether the double taxation agreement with the UK will override that ability to tax him. In other words, usually you look at the 183-day rule in a treaty, and that should protect him for that period. But if the person stays longer than 183 days, he's taxable from day one, and therefore he has to make up for the past if there was no deduction or no pay-as-you-earn withheld. But because a non-resident employer is not liable to deduct pay-as-you-earn in South Africa, the employee would have to pay provisional tax. Unless, like Helen said, if that company is liable to register here as an external company under the Companies Act, usually what happens then is SARS will send that company the tax returns and also register them or require them to be registered from a tax perspective, and then they will also be a employer registered as employer. But maybe Aneria, you can expand on that.
Thanks, Wally. Yeah, there are, I'm afraid lots of the explanations or the answers we're giving you today is that it's not clear. And this is one of them. In principle, if you have a non-resident employer with an employee in South Africa, there isn't an obligation to withhold employees' tax. But if the employer has a representative taxpayer who becomes liable to withhold, or liable to pay remuneration, then there will be an obligation to pay employees' tax. And together with that will come on contributions to unemployment insurance fund and also skills development levies. But there are also lots of nuances and variances to that. So again, it is important to obtain advice as to whether there could be any registration obligations for the foreign employer in South Africa. If we can move on to benefits, Helen, so you've got an employee for UK company working in South Africa. Is there any obligation to belong to a South African retirement fund or to contribute to a South African medical aid?
No, and this is assuming that this is your only individual who just happens to be in South Africa. You don't have an entity where you're providing this benefit to other employees, because then it could be a discrimination issue. But let's say it's just they're the only individual working here for personal reasons. There'd be no obligation. It's contractual, and normally you wouldn't, because from a scale, when you've only got one employee, it wouldn't make sense to have a company retirement fund. You would normally just factor it into their remuneration, and they would make their own arrangements, whether in South Africa or another jurisdiction.
Thanks, Helen. Listen, I'm assuming that from a UK law perspective, there also wouldn't be an obligation to remain a member of a UK retirement fund, or am I oversimplifying it?
Pensions here are done by contribution, and it's based on, it's only beneficial really if you're a taxpayer in the UK. So if someone remains a taxpayer in the UK, there's no reason that the employer would not continue to make contributions for the employee and the employee too.
Yeah, and again, the rules back to what we were discussing earlier about sort of the 183 days test. Are you on a short-term secondment, or are you working for a longer period? They're also under the withholding tax rules in the UK. Again, they're complex, and there is an obligation to continue paying UK national insurance contributions for the first 52 weeks of employment in the UK, if the employer is based here and the employee is ordinarily resident in the UK and was resident here immediately before starting work abroad. Again, subject to sort of treaty overrides, etc. But you know, the rules are complex, and you would have to sort of look at them. There are sort of short-term sort of holiday rules as well, and there's a number of exceptions which would need to be looked at to see whether they're applicable.
Thank you, Simon. Again, just going back to what we see in South African retirement funds is often the rules do not really take in consideration where the individuals are based. I think traditionally the assumption was that if you work for a South African employer, it would be in South Africa and it would make sense to belong to a South African retirement fund. So one would obviously need to look at those rules as well. I'm aware of the fact that we've only got 4 minutes left. Wally, I would like to go over to you. We've spoken about permanent establishments. If you've got an employee of a South African company working in the UK, but the reverse, if you have a UK employer with an individual working in South Africa, our rules aren't quite as, I think, clearly defined as the UK rules.
Yeah, you have to first look at whether the South African individual creates South African source income for the employer, which is a bit unlikely, but it depends whether the UK employer has a business in South Africa. If there's no business here, it's very unlikely that it will create any South African source income for the employer, and therefore, even if the individual complies with the permanent establishment provisions under the treaty, there may be no tax liability because there's no South African source income for the UK employer. So yeah, it depends again on the situation and the circumstances.
Thank you, Wally. I'm going to start wrapping up. I know that people may have other calls at 12 o'clock South African time or earlier in the UK. My apologies for, I know that we've got a mixed audience, so we've got some employment lawyers or people from an employment perspective and some tax people. And I know that we speak different languages. I think that what we would want you to understand going away from this webinar is that there has definitely been a shift in how people look at the mobility and working internationally. And it's not only in South Africa and the UK. Many jurisdictions struggle to accommodate that. They don't really know how to deal with it because it doesn't fit in with a normal way of working. But there's definitely a movement in that regard. I'm obviously very biased because I live in Cape Town, and I know that the question has been asked, if you can work anywhere in the world, why not let it be Cape Town? So I'm a proud Cape Townian, and I can attest to that. But hopefully in time we'll see some relaxations from an employment law perspective, from a tax perspective, to make this possible for individuals to have that flexibility without complicating matters for their employers. Thank you very much to the panel, and thank you to all of you. My apologies that we couldn't deal with all of the Q&As or the questions that came in, but you're welcome to contact any of us should you require further assistance in that regard. Thank you all.
Thank you.
Thank you.
Thank you.
I've just heard, for those who are familiar with Cape Town, we've got a noon gun, and I've just heard the gun go off. So it's 12 o'clock, so that's right on target. Thanks, everyone.